Imagine this, a single, furious verbal outburst from your boss. Go home and never come back after a disagreement. Can that one heated command truly stand as an illegal dismissal in the eyes of the law, especially if you then refuse to sign a resignation letter they push on you? This isn't just a hypothetical, It's the core question at the heart of Tapia v. GA2 Pharmaceutical Inc., a really pivotal Supreme Court case. GR number 235725, decided on September 28, 2022. It's resonated across workplaces. So today, we're taking a deep dive into its profound implications for every single employee. Our mission today is to unpack the twists and turns of this landmark case. We'll look at the conflicting narratives, the very different decisions from the lower courts, and finally, the Supreme Court's definitive ruling. We really want to help you, our listener, understand what this means for your employment rights and how similar situations, how they might play out in your own professional life. Okay, so let's start at the very beginning. Every legal case, especially one like this, it starts with a story. And often, like here, we get two very distinct versions. In this deep dive, we have Joel Tapia, the employee, and GA2 Pharmaceutical Inc., the company. From Tapia's perspective, what was his account? How did he say his employment went? And crucially, how did the separation happen?
Right. Well, Tapia's narrative paints a picture of, a pretty dedicated employee. He claimed his journey with GA2 started way back in July 2013. He was hired as a pharmacist, earning P16,000 monthly. He laid out his work schedule's standard stuff, Mondays to Fridays, 9 to 6, Saturdays, 8 to 3. And to back this up, he provided proof payslips from July and August 2013. And here's a really significant detail. He also presented GA2's FDA license.
An official license.
Exactly. Dated August 22, 2013, and it actually had his name on it as the resident pharmacist for their Mandaluyong Young branch. That's pretty strong evidence for his start date, wouldn't you say?
Absolutely. It really grounds his claim right from the get-go. So He wasn't just a recent hire, according to him. What happened as his time with the company went on?
That's right. His role apparently evolved quite a bit. He wasn't stuck in one place. He became a roving pharmacist, covered NCR, Cavite, Bulacan branches, and beyond just pharmacy work, he was handling operations, product delivery, even sales collection. That's like a pretty varied role.
Okay, so a long-term employee with expanding responsibilities.
According to him, yes. Then we get to the core incident. June 11, 2015. Tapia stated he needed to be excused from a delivery. He said he was feeling unwell, and also the company car was under number coding that day. Couldn't use it.
Okay, seems reasonable enough. But this is where things allegedly took a sharp turn, right? Leading to the dismissal claim.
Precisely. Tapia claims that Lancy Vijay Saldana, who was the general manager at GA2, completely lost it. He allegedly scolded Tapia quite harshly. Then, apparently, he ordered the personnel officer, Evelyn Zuniga, to immediately draft a resignation letter for Tapia to sign, right then and there.
Wow, a resignation letter on the spot.
Yeah. And when Tapia refused to sign it, which is a crucial point, Saldana reportedly, and I'm quoting Tapia's account here, shouted and abased him in a very loud voice. And then came the direct command, go home and never come back.
Go home and never come back.
Yeah.
It's incredibly stark. Unambiguous. So what was Tapia's immediate response to being verbally fired like that? Did he just, accept it?
Not at all. And this is really important for how the case unfolded. Tapia acted incredibly fast. Just 4 days later, June 15, 2015, he filed a complaint for illegal dismissal. He used the single entry approach, SENA, which is that mandatory conciliation process. Then he followed up, filing a formal complaint in July and specifically amended it to a legal dismissal in September. His quick action, filing almost immediately, becomes a key factor later on.
Okay, so Joel Tapia's side is detailed. Long-term employment, evolving role, a sudden heated verbal dismissal, and immediate legal action. But like you said, two sides to the story. GA2 Pharmaceutical must have had a very different take. What was their defense?
Oh, completely different. A stark contrast. GA2 claimed Tapia wasn't hired in 2013 at all. They said he started much, much later, March 25, 2015. And crucially, they argued he was only on probationary status. They even presented a probationary contract to support this later start date and status.
Probationary. That changes things significantly, if true.
Exactly. And they didn't stop there. They claimed that after just 1 month, Tapia's performance was poor. And he was frequently reprimanded because he had difficulties getting along with coworkers.
So they're painting him as a problematic, short-term probationary employee. What about the incident itself, the one on June 11th?
Yeah.
Or was it June 9th for them?
Right. Their timeline differs slightly, too. They pinpointed the key incident to June 9, 2015. And in their version, Tapia simply refused a scheduled delivery. Then, according to GA2, he had an altercation with Saldana, the GM, and just walked out. left the office and never came back. They framed it as clear job abandonment.
Abandonment. So he wasn't fired, he just left.
That was their core argument. They also claimed Saldana tried to get his secretary, Ashley Bernardo, to contact Tapia, but Tapia supposedly wouldn't take their calls. So as a result, GA2 said that on June 15, 2015, ironically, the same day Tapia filed his SINA complaint, Saldana sent Tapia a notice to explain. An NTE.
A settlement notice.
Yes, supposedly sent via registered mail, asking him to explain his absences without leave. And to bolster their side, GA2 submitted affidavits from Tapia's co-employees about that June incident, claiming these supported their story of Tapia abandoning his job.
Wow. So we have illegal dismissal versus job abandonment. Long-term regular employee versus short-term problematic probationer. Completely opposing realities presented to the courts. This is where it gets really interesting, isn't it? Because with such totally different accounts, the case went through the legal system, the Labor Arbiter, the NLRC, the Court of Appeals, and they didn't agree, did they? How did each level rule? It sounds like a real roller coaster.
It absolutely was a roller coaster, a perfect example of how tangled these cases can get. Okay, so first stop, the Labor Arbiter. Their decision came down on January 29th, 2016, and they dismissed Tapia's complaint completely. The arbiter basically said Tapia didn't prove he was arbitrarily dismissed. They found GA2's evidence, like the NTE and the coworker affidavits, more convincing than Tapia's own account, which they called self-serving allegations.
Ouch. A total loss for Tapia initially? That must have been tough. But then the National Labor Relations Commission, the NLRC, got involved.
Yes, and they flipped the script entirely. On June 30, 2016, the NLRC reversed the Labor Arbiter. They declared Tapia had been illegally dismissed.
A complete reversal. Why?
Well, the NLRC found Tapia's detailed story categorical and, importantly, not directly refuted by Saldana himself. They also viewed those coworker affidavits differently. They considered them self-serving, basically saying, look, these people still work for GA2, their jobs depend on the company, so maybe not entirely objective.
That makes sense, the power dynamic.
Exactly. And critically, the NLRC noted there was no actual proof that Tapia ever received that notice to explain GA2 claimed they sent. That undermines the whole due process argument from the company. Plus, they found GA2's claim about him being probationary seemed like an afterthought, brought up late. And maybe most importantly, they ruled Tapia's immediate filing of his complaint totally negated any idea of job abandonment. Why file if you intended to abandon?
Right, his actions spoke louder. So the NLRC sided strongly with Tapia. That's a huge win for him. But the ride wasn't over yet, was it? The Court of Appeals had another take.
No, not over yet. The Court of Appeals weighed in on July 12, 2017, and they complicated things again. They partially granted GA2's petition. Their ruling was nuanced, ordered Tapia's reinstatement, but without back wages.
Reinstatement without back wages. Why the split?
Well, the CA kind of circled back to the Labor Arbiter's concern about proof. They felt Tapia still hadn't definitively proven the dismissal itself. They again called his allegations self-serving. And they pointed out, look, he never even produced that alleged resignation letter Saldana supposedly ordered. So they doubted the core dismissal event happened exactly as he said.
Interesting. So they questioned the dismissal itself, but what about the abandonment and probationary claims from GA2?
But here's the twist. Even while doubting the dismissal proof, the CA also rejected GA2's main defenses. They agreed with the NLRC that GA2 failed to prove abandonment. And they also struck down the probationary status defense, saying GA2 hadn't shown they properly informed Tapia of the performance standards needed for regularization when he supposedly hired on probation. That's a requirement.
So a really mixed bag from the CA. They didn't fully buy Tapia's dismissal story, but they also didn't buy GA2's abandonment or probation story either. Left things quite messy.
Exactly. A truly conflicting set of rulings. The case just swung back and forth, highlighting how tough these he said, she said situations are in labor law, especially proving dismissal versus abandonment and nailing down employment tenure.
And this conflicting mess, of course, is what paved the way for the Supreme Court. They had to step in and provide the final word. So let's get to the resolution. What does this all mean for Joel Tapia, for GA2, and most importantly for you, our listener, trying to understand your own rights? The Supreme Court finally stepped in. What was their ultimate decision, and crucially, what was the reasoning behind it?
Well, the Supreme Court explicitly noted the inconsistent findings from the lower bodies. That inconsistency is what allowed them, and frankly compelled them, to review the factual issues themselves, which they don't always do. And their decision, in GR number 235725, dated September 28, 2022, was definitive. They reversed the Court of Appeals and reinstated the NLRC's decision in full. They found unequivocally that Joel Tapia had been illegally dismissed, a complete vindication for him after that long legal battle.
Yeah, it's a powerful outcome. So the highest court basically agreed with Tapia's version and the NLRC's assessment. What were the core points of their reasoning? Why did they land there?
Their reasoning is really insightful. First, they found Tapia had sufficiently established the circumstances attendant to his dismissal. They pointed to his detailed, consistent account of that June 11th incident being sick, the car coding, Saldana getting angry, ordering the resignation letter, the shouting, and that very direct command, go home and never come back. That level of specific detail, combined with his immediate actions, made his account credible in their eyes.
And the verbal command itself, that was so contested. What did the Supreme Court say about whether just words can constitute dismissal?
This is arguably the most critical point and a huge takeaway for everyone. They cited a previous case, Reyes v. Global Beer Below Zero from 2017. And based on that precedent, the Supreme Court affirmed that, yes, a clear verbal command not to report for work, like go home and never come back, when uttered by someone with the authority to fire you, like the general manager, that can be considered an overt act of dismissal.
So words alone can be enough.
Yes. If they're direct, come from the right person and essentially tell you you're done. The court said this verbal command was the dismissal. No formal letter needed in that moment. And again, Tapia's immediate filing of the illegal dismissal case just reinforced that he understood he'd been fired and didn't accept it. It made his story much stronger.
That clarity on verbal dismissal is massive. What about those affidavits from the coworkers that GA2 used? The lower courts were split on how much weight to give them.
The Supreme Court was quite clear and, frankly, quite pragmatic here. They essentially disregarded the coworker affidavits, calling them self-serving. The reasoning: these employees were naturally beholden to GA2 because their employment depended on the company. It acknowledges the real-world pressure employees might feel. Plus, the court noted the affidavits didn't even directly deny Tapia's main claim, the fact that Saldana shouted at him and told him to leave and not come back. They didn't really address the core issue.
Okay, so the affidavits didn't hold up under scrutiny. And the abandonment claim?
Completely negated, the court said, by Tapia's immediate action against his dismissal. You don't immediately file an illegal dismissal case if you intended to abandon your job. Simple as that. Plus, that lack of proof that Tapia ever received the notice to explain, that also weakened GA2's position significantly.
Right. And finally, that crucial dispute over his start date and whether he was probationary. How did the SC resolve that?
They sided firmly with Tapia on his July 2013 start date. They gave weight to his early evidence. The July and August 2013 payroll slips, and importantly, that August 2013 FDA license with his name on it as the resident pharmacist. GA2's later evidence, the March 2015 probationary contract, the affidavit from a former employer, the court dismissed these as a mere afterthought and too late in the day. They came up too late in the proceedings compared to Tapia's initial consistent evidence.
Incredibly clear reasoning from the Supreme Court, tying all the threads together. So, as a result of finding illegal dismissal, what did the court order GA2 to provide Tapia?
They reinstated the NLRC's original award. This means GA2 had to pay Tapia back wages, separation pay instead of reinstatement, often preferred when the working relationship is strained, and attorney's fees. It's worth noting the attorney's fees were directed to the Public Attorney's Office, the PAO, as a trust fund since they likely represented him. The case was then sent back to the Labor Arbiter just for the number crunching, the final computation of the award.
A long journey, but ultimately a complete victory for Joel Tapia. This brings us right to the core. What does this landmark ruling mean for you, the employee listening? What are the essential lessons from this deep dive into Tapia v. GA2 Pharmaceutical?
There are several really critical takeaways here, practical points for every employee. First, the burden of proof. If you claim illegal dismissal, you first need to establish the fact of dismissal. It requires clear, positive, and convincing evidence. This means more than just saying I was fired. It means a detailed account, like Tapia's, and evidence of your actions right after, like filing that complaint immediately.
So documenting everything and acting fast is key.
Absolutely. Second, and this is huge, verbal termination can be dismissal. This case confirms it. A direct verbal order, go home, don't come back, you're fired from your boss, or someone with firing power can be legally recognized as dismissal even without a termination letter at that moment.
That empowers employees significantly.
Definitely. Third, keep your records. Proving your employment details matters. Pay slips, company IDs, contracts, licenses like Tapia's FDA license, anything official with your name, role, and date. Keep copies. They are crucial if your employer later disputes your start date or status. Fourth, Immediate action negates abandonment. If you believe you've been unfairly dismissed, especially verbally, file that Senate or formal complaint immediately. It's your strongest defense against a later claim that you abandoned your job. Your swift action proves you didn't intend to leave.
Don't just walk away and wait.
Precisely. Fifth, credibility of witnesses. The court looks closely at evidence like coworker affidavits. They might be seen as self-serving if the witnesses depend on the company for their jobs, especially if the affidavits don't directly address the main issue. And finally, a point on probationary rules. Employers have to be clear at the time of hiring about the standards for becoming a regular employee. If they don't explain those standards properly, it weakens their ability to claim you were just probationary later on. Overall, this case really underscores the court's role, especially the Supreme Court's, in protecting labor rights and ensuring due process, even when the facts are messy and contested. It shows the importance of proper procedures, yes, but also the weight given to credible employee accounts backed by action.
So thinking about this whole deep dive, what stands out most to you? Any surprising facts or aha moments from Joel Tapia's fight that really resonated? We'd love for you, our listeners, to share your own thoughts and favorites from this discussion in the comments.
For me, it's a powerful reminder, really. The path to justice can be incredibly long, winding through different courts with conflicting views. But this case shows the system, particularly the Supreme Court, acting as that final check, meticulously examining the facts and applying principles to protect fundamental rights, especially for workers who might feel less powerful. It shows the importance of persistence.
Absolutely. And if you found this deep dive valuable, just think about the insights you could gain from our future explorations. Don't miss out on staying informed. Please make sure you hit that subscribe button, follow us wherever you get your podcasts, and maybe share this deep dive with a friend or colleague who could use a shortcut to being truly in the know about crucial labor law topics like this one. Until next time, stay curious and stay informed. And just one final thought to leave you with. In our world now, so much communication is digital. Could a simple text message from your manager, maybe saying, "Don't bother coming in tomorrow," carry the same legal weight as that verbal command did in the Tapia case? Something to definitely ponder as you navigate your own career.